Hello everyone, welcome to this channel Study Creatively. Hope you will like this video, and if you do, then don't forget to like, share and subscribe to the channel to get more such daily stuff. Now today what we are going to be doing is fundamentals of partnership. We all know what is partnership. Partnership is the relation between persons who have agreed to share the profits of a business carried by all or any of them acting for all. So, this definition that I've taken here is from this section 4 of the Indian Partnership Act 1932. Okay, so this is the definition that you need to go through to understand what the partnership is. Now, before talking about partnership, we know that there are various forms of business organizations. There is partnership, sole proprietorship. Now, before partnership, you have done accounting to sole proprietorship, where you know that you used to prepare trading account, profit and loss account, and the balance sheet, and then you even know that how the company accounts to be made. Maybe later into this very particular class, you are going to be learning how company used to maintain its accounts. Now today the topic is how partnership, like the theory part. Okay, I'm going to be discussing today about the partnership. Now we did the meaning. Now moving on to this point, which says the persons who have entered into partnership are individually known as partners and collectively as a firm. So you need to remember this, what is firm and what is partnership. So partnership is nothing but the group of persons who have came into this contract, this agreement, that they will carry on the business, whereas the firm is collectively how do they all resemble themselves, and each individual who is engaged into the partnership is going to be called as the partner. So remember three words: partner, partnership and firm. They all are different from each other. Then from the accounting point of view, partnership firm is a separate business entity. Remember this, like when we are talking about accounting point of view, we are going to see, or we are going to say that the partnership is different and partners are different, or you can say the firm, partnership firm is separate than to its partner. So any partner's death, retirement, admission doesn't affect the normal life of the business, doesn't affect the operations of the business. So this is something that separate legal entity means. So hope you will keep this point into mind, that separate business entity means what, and that is from the accounting point of view. And when you look legally, then with the legal point of view, it is not a separate legal entity. So remember the two things when you are talking about legally, then legally partners and partnership firm is same, whereas when we are talking about partnership firm and the relation of partners with accounting point of view, we say they are separate. Okay, then it means in case of the firm is bankrupt, private assets of the partners are used to meet the deficit. But if there is like any retirement, admission of a partner, business will still continue as on the wish of partners. Okay, so this was about the meaning and the points that you need to know about the partnership. Now moving on to the features, characteristics or elements of partnership. Now we know that features are 6. The first feature is association of 2 or more persons. Second is agreement. Third is mutual agency. Fourth is business may be carried by all or any of them acting for all. Okay, so this is the fourth feature. Then fifth feature is sharing of profit. So the partners who are there, they used to have the right on the profit. So each partner has the right on profit. So how many partners are there into the partnership firm, they all will distribute the profit according to the work they perform, according to the like agreement into which they have entered. Okay, then sharing of profits, and 6th point is liability. Then you have rights of the partners to remember. So the question can come like, what are the rights of the partners? And after completing this chapter, even I'm going to be providing you with the important questions. So please click on the notification button so you will get the update of the upcoming videos. Okay, then rights of the partners, then right to participate in the business, then right to be consulted in affairs of the business, right to inspect the books of accounts and have a copy of it, Then right to share profit or losses with others in agreed ratio. Okay, agreed ratio, because we are not talking about specific old PSR or new PSR. They used to get changed. Okay, here we are talking about whatever is agreed between the partners, that is what they need to go through. Okay, so these were the few rights that we talked. Now coming to the very important point, which is partnership deed. You need to remember this. In the partnership deed, it is a written agreement. See, when we talked about the features or characteristics, we said there has to be the agreement. When partnership used to start, should be based upon an agreement. This agreement can be oral and can be written, both in the form. Okay, it can be oral or it can be written. Now if the partnership agreement is the written agreement, we say it is a deed among the partners as per Indian Partnership Act 1932. It is not mandatory to have partnership deed in writing, but it is a better option to have a written agreement to avoid conflict in future. Because when we say, like, what used to happen is, I said something today, but as the time changes, circumstances changes, and if the circumstances are in against me, then I could flip with my words. So what is better is to have a written agreement, everything into writing. So in any point I could not avoid, I could not neglect, I could not flip to my words. Then what are the terms that is a part of partnership deed? So first is description of the partners. So partnership deed has to has descriptions of the partners. Then the terms that it has in the partnership deed is the firm ka description, then principal, place of business, nature of business, commencement of partnership, capital contribution, interest on capital drawing, etc. So these are nothing but these are the terms that partnership deed contains. Okay, then if the partnership deed has clauses different from the provisions of the Indian Partnership Act 1932, the clauses of partnership deed will apply and not the provisions of the act. So you have to remember, like, if partnership deed has clauses different from the provisions of the Indian Partnership Act 1932, we know that for all the partnership firms we have an organization which rule over them. Like we know about SEBI, Security Exchange Board of India, has the regulation power on all the companies of the country. Similarly, Partnership Act 1932 guides the partner how to run the partnership firm. So if your provisions of the Indian Partnership Act 1932 are different from what you have made in deed, like agreement is on between you and your partner, so it would be obviously on your choice. Okay, but of course the provisions when have been made by the government or by the anybody in the Indian Partnership Act 1932, they are in favor of all. Okay, they are being kept, they are being made in favor of all, in a keeping everything, every situation into the mind. So it could happen that the partnership deed, the clauses that there are in partnership deed, they could differ from the provisions of the Indian Partnership Act. So the clauses of partnership deed will apply if you have deed, because deed is not compulsorily to be made. Like if you talk about any journal partnership, like अगर आप पढ़े लिखे हो, सो आपको पता है पार्टनरशिप कर रहे हैं अगर 2 से 3 लोगों के साथ, so you know that you need to go to the agreement, you need to have the agreement among the partners. But if there is any person who haven't studied about partnership, they don't know how to carry out that, and they all come together, then into that case what is going to happen, they won't be writing everything and they are going to show everyone that this is what we have decided in between. But what they instead do, they will trust each other. Okay, there is a mutual trust that will be there among the partners, and orally they would be running the partnership business. Now that is different, like that the deals that you've made, like the person can flip, as I just said, so that is better, it is advisable to have the deed. And if you have the deed, okay, so deed is not compulsorily to be maintained, but if you have it, then whatever the provisions are written into the deed are only going to be applicable, and not then the provisions of the Indian Partnership Act 1932. So remember this thing. Then if the partnership deed is silent on a particular issue of the partnership deed, the partnership deed is not entered, then the provision of the act shall apply. Very important point. You need to remember this. Like, if you don't have deed, or if deed is there but the specific point in which today the conflict has aroused, you haven't thought that this would be the cause of conflict between the partners, but it is now. So you don't have any provision in the partnership deed that you have maintained, but then into that case you have to resolve that particular fight. So to resolve it, you will go to the Indian Partnership Act 1932 act. You will check the provisions of that act to find the solution of your problem, and that will be getting through this act, because that is not there into the deed. Then, provisions of the Indian Partnership Act 1932. Please do remember all the provisions. They are very, 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 very important. Okay, provisions of the Indian Partnership Act 1932 that are applicable in the absence of partnership deed. So the first provision that is there is sharing of profits or loss are shared equally. Okay, if you haven't maintained a partnership deed, or if you have maintained but there is no clause regarding how you will share the profits with the other partners, or what will your share into the profit or loss, then you are going to check the Partnership Act 1932 to determine that. Okay, and according to Partnership Act 1932, the provision says that you have to share profit and losses equally. Okay, equally. Then interest is not allowed on capital. Okay, interest is not charged on drawings. Interest on loan by partner is allowed at 6% per annum. Please remember this percentage. This percentage is provided. This is a percentage for interest to be provided to the partner for the loan he has given. Okay, interest on loan is a charge against profit. There will be two terms that we are going to be discussing in the next part: charge against profit and appropriation of profits. Okay, that we are going to look at the next part. For brief, charge against profit are those items which have to be made, either you have profits or not, but you have to make them. Like interest payments on debentures or बैंक लोन में अगर आपको इंटरेस्ट पे करना है, you have to pay that interest, no choice. Okay, whether you have profits or not, you have to carry out those expenses. Okay, remuneration is not paid. Then new partner cannot be admitted unless all the partners agree. Okay, so these are the provisions that there are in the partnership deed. Okay, in the provision of the Indian Partnership Act 1932, when partnership deed is absent. Okay, so on the absence of partnership deed, you are going to be following these all provisions, which are very important to get remember, because questions can come in indirect way, or to just to check that whether you have gone to the theory part or not. So yeah, just keep all these things in mind, and that's it for today, and I will be uploading the next part of the videos very soon. If I've And please do motivate me by likes, shares and subscribe to the videos and the channel. That really helps me to post daily. Okay, thank you so much.